pleased to stand before you here today, this afternoon, to join us in this very important session. And because of that, I'm going to highlight and explain a few things which in most of the time many of us find difficult to understand why they're important, their relevance and place in society. My brief highlight is focused on standards. In most cases, we are used to talking about laws and regulations and legislations, but standards do not feature so much in our discussions. And it's important that we highlight this a little. Now, the first thing is why do we actually need standards? Standards are more or less regulations, but they are often more precisely called technical regulations, especially when they have been adopted as extensions of laws or policies. Standards are developed by standards bodies. In some cases, we might have other entities called standard setting organizations and standard developing organizations. There's some difference, but we're not going to get into that. At this level, we are going to talk about focus on the standards developing organizations. Now, standards provide frameworks, guidelines, specifications, codes and practices related to specific products or services. And it becomes clear that we are the consumers and users of these services and of these products. And therefore, the development of these standards should really begin to trigger some thoughts in our minds as to what do these standards say about the services we receive, the products we consume, and so forth. So in every country, we have what we call the national standards body. So at a national level, we have what we call the national standards body, which is responsible for the development of standards which are applicable at the national level. We can have these differentiated when we talk about, you get to lower level, for example, sector, industry, field, so at that lower level we can have different standards which are applied at that lower level. But we are focusing on one standard today, which is our main focus on e-accessibility. But before we go to that, I should now highlight or emphasize that given that standards give specifications for requirements on products and services that we use, then it is important that standards developing process be inclusive, engaging, and based on what we call consensus, so that the users or the persons who will be affected by the outcome of such a standards are involved and are aware and appreciate the role of that standard. So those principles of engaging the affected persons, the users, it's important to emphasize that this standard was proposed by a potential user or someone who is affected by accessibility issues. Now, that brings us to principle number one, that any person or any organization has got a right to propose for the development of a standard that will affect their operations, their business, their products, their services. And that is exactly what happened in this process. Within this room, there are a number of people who participated, but we should say first that Enable Kenya made the proposal to the Kenya Bureau of Standards to have these standards developed. And fortunately, there was a reference which was based on the EU standards 301549 on e-accessibility of products and services. So that European standard became the primary reference. And it was taken through a lot of deliberation, discussions, to customize it and make it more understandable and usable in our context. So we ended up with two standards, a part 1 and a part 2. Now, you may ask, why did we end up with these two parts? We understood the participants who were involved in this process, of course, with the Kenya Bureau of Standards being the secretariat, that as a paralegal document, we envisage that at one point there would be need to invoke regulations to ensure that there is some compliance, derived from the legislation or a regulation. Otherwise, meeting the requirement of the standards would be naturally referred to as conformance. So part 1 of the standard covers the requirements for a product or a service to meet accessibility principles. And then part 2 deals with conformance assessment for products and services. And after almost 2 years of discussions and approvals, taking the standard through various stages of approvals, the standard was finally published in a Kenya Gazette as an official government document. That is the essence of publishing these documents in a Kenya Gazette. So it's officially a government document which can be referenced and can be used by the various entities. Now, I've covered who should be involved in standard development. That includes me and you, legal persons or natural persons. That means including an organization or anybody. And then this starts from the proposal stage all the way to the discussions and so forth. Now, there are a number of steps which take place through, which we may not explain how they go through. But the principle remains that every individual has got the opportunity to participate and to contribute. Now, it is natural that humans have always interacted all over, and that is why we read from history that traders often traversed deserts, crossed seas, crossed waters, and nowadays we fly to other places so that we can do business and trade and share the experience of different cultures. And because of this, it is also essential, therefore, that as we interact from one region to another, that issues that affect us, the accessibility issues, are also considered in the various environments that we find ourselves. So what does that mean? That means that if we are going to consider accessibility issues, therefore, these issues must expand beyond a region, beyond a country, and meet the needs of humanity, everywhere. And this is why, such a forum is important to expound on this matter And that is why the application of e-accessibility standards should grow beyond a country. And on that note, therefore, I may now stop and invite my fellow panelist here, Engineer Ruben, who is responsible for the development of standards at the ARSO level, that is at the, which we refer to as the African continent. Thank you so much. I hope you will have time to ask any questions, maybe for clarification on any other matter. Thank you. Welcome, Engineer.
Thank you, Mika. Good afternoon. Yeah, I hope you are alert. Before we start some heavy discussions, unfortunately, I'm not very familiar with sign language. Maybe next time I'll call my daughter to do it for you. She had the passion to stop learning other courses and took the sign language and the skills for those who cannot talk, for those who cannot see. And that's what she actually teaches, which makes me feel like it is a kind of duty that we all should do. We have diverse populations in the continent, and we have a duty to ensure that they benefit from the services that all the others also do. I take it from what Mika has presented, that standards are actually stakeholder-driven. When the stakeholders require certain laws, certain standards, certain services, they have the right to ask for those to be provided. And that is what we emphasize, that any standard that is not supported by a stakeholder is not a valid standard. So I think all the stakeholders who have held out steadily to ensure that we provide the standards and any other enabling instruments in this sector. So how do we do the continental standards? Ordinarily, any stakeholder can actually come to ARSO. You can access the website. I'll check whether it has that capability of being accessed by all, but that is what we are going to be working on. That you can access and you can actually key in what you require, and it should be responsive for all those activities to be possible. So directly you can do that, but you can also do it through the national standards body. You can do it through an association. We do have institutions in this country that are responsible for people of all categories, and they can require a standard. Now, why do we need a standard beyond the national boundaries? I believe that in many of your forums, you interact with people from various countries. And when you do that, it means we need to have harmonized standards so that they do not provide requirements which are contrary to what you have at the national level. We also need to ensure that the framework for implementation of such standards is harmonized across the continents. Many times we have done standards, very good standards at the national level, very comfortable with ourselves, but when you go to the other countries, you find that the way they are done is different. And therefore, you cannot proceed with any engagements that you may wish to have with in those countries. So what has taken place, and this is an update, is that when through Enable, the demand for a continental standard or continental standards for e-accessibility came in, Kenya Bureau of Standards took the initiative and filled in the form for a new work item proposal and sent it to ARSO. Now, when they did that, we looked at our committees, because we work through technical committees. We realized we did not have those technical committees, and therefore we requested our higher committees to establish a committee for e-accessibility. So we do have right now a committee that is ready to actually work on that. And what is now remaining, we have started mobilizing the countries. We already have 4 countries, of course, Kenya included, South Africa, Egypt, Nigeria. We need to move more, because in our rules, it requires 6 countries as a minimum to make the work valid as an African standard. So we have 2 more to go, and we are going to ensure that we get those countries on board. So why is it important? You understand that we are having, as a continent, for example, the African Continental Free Trade Area, and a lot of emphasis is being put on electronic transactions. And when it is like that, we need to make sure that these electronic platforms are accessible and they do not create barriers. And for that alone, we do have the obligation to ensure that the standards are harmonized, the stakeholders are sensitized, the policymakers are made aware that they need to do this, because in some countries or in some societies, making services available to those who cannot do them conventionally is considered as an extra cost. And this has been for a long time the problem, that people think providing services to those who cannot access them conventionally is not a priority. We need to make sure that this is understood and taken as part of the normal functions of any government, not to start telling us that these are not easy things to do. They should budget for that. So we got the form from Kenya Bureau of Standards. Now that is an official request. We have established a committee. Now we need experts. Apart from having the countries, now we need experts. Who are the experts? You understand experts? Experts can be those who have learned how to make sure that this accessibility is made possible in a manner that the users find easy and friendly to use. But equally, we need the stakeholders. You know, in the committee, you will have the experts, those who are educated in that sector. Then we have those who know how to make services accessible by use of various electronic tools. But then we also need the actual users to be represented so that they can say, yes, this is possible from the beginning, not at the end. Because the mistake we make sometimes is assuming that we are so perfect, we want to give you the final product. And then you find that it is not working. Once we have that, then the committee will have sessions. First session, we are lucky that there is already a Kenya standard existing. There is the initial reference of the European standard existing. But remember, here now we are going to be dealing with more than one country. And therefore, you need to get them to buy in and tell you whether the standard is providing for what they know. Some things could be universal. But remember, the continent has histories that are not the same. Others were colonized by Portuguese, others were colonized by the British or English, others were colonized by Spanish, others French. Some speak, like Egypt, you'll find that they speak Arabic most of the time. So we need to get all these people on the table to give their views. And that's why we cannot easily adopt a standard without having discussions that you gather information, you gather the inputs from all the stakeholders that we target. That is how it is at the continental level. At the national level, it is easy. You have one legislative framework. Perhaps like in Kenya, we speak Swahili, all of us, or English, but also, you know, so the laws we serve under are the same. But now when you cross the borders, they are not the same. Even when it is like Nigeria, which was also colonized by the British, same as Kenya, you might find that legislative frameworks are different. That is the difference. We, in the committees, need to build consensus. After we have built consensus at the committee level, we need to move towards having public participation. I know in Kenya, when we say public participation, it is political. But in that process was actually in our standards framework long before it came into the legislative framework in countries like Kenya. So we used to have what we call public review since we joined the standards bodies. Public review means you give access of these documents to a wider audience of the users of that who could not come and sit in the committee. At that point, it takes longer. You have to give people a long duration. Make sure you can, and that's the time you can also sensitize the people about that particular standard. Once you are through with that, if you don't get a lot of, divergent comments, then it means you are closer to consensus. From that point, we look at the comments, we take the inputs from the others, and we issue a document we call a balloting draft. Balloting draft is basically a document where the stakeholders in the committee, not now the public, in the committee, say yes or no. If they say yes and you have a majority of 75%, it is approved. But the 25% are not ignored. You have to understand why they objected to that document. And perhaps the objection was serious enough that could make the standard to be revised to improve it better. So that's how it goes. Once it is balloted, we take to the ARSO Council. That's the body that approves our standards, and they become African standards. That process, because we already have a draft, we expect for it to take 18 months at most, or less. Now, it takes money. That is one challenge I have to put to you, that such processes are not done free of cost. They require money because the experts must meet, whether it is virtually or in physical meetings, for them to agree. And while they are agreeing, they need accommodation, they need food, they need water, like what we have on the table. So those costs must be taken into account. Yeah, I have to make it clear that, so that people don't think standards are cheap. Actually, they are expensive. And that's why we always need those who can assist to step in and assist, those who can contribute by whichever means to contribute, so that we work and get these things done. Unfortunately, governments do not always have a lot of money to give out. As I said, in standards development, whether it's at the national level, that cost has to be met. And is one of the biggest challenges that makes it impossible or very hard to get as many standards as possible. Because by our estimation, sometimes one standard costs not less than 100,000, when it is very quick, $100,000, not shillings. So that is if, for example, we are just doing in one country. But if we are doing more, then the cost is higher. We will work on it. I know where there's a will, as we say, there is a way. Palipo na nia, pana njia. Isn't it? I hope all of you speak Swahili. So if you don't, but it still means the same, that where there's a will, there is a way. And that is what we indeed need to do to ensure that we have an inclusive society. I thank you very much. You can ask questions when the time is due. Thank you.
All right. Thank you, Engineer. I would like to give you a short story. The story is about two insects. And we may be familiar with these two insects. One of the insects is quite graceful, beautiful, and nice to look at, full of colors, but it has got a unique behavior. The other insect is tiny, a little tinier, but is very mean and very serious. The first insect, which is graceful and beautiful, highly colored, we don't get nothing serious from it. But the second insect, which is mean and very serious, we get nice thing from it. Now, these two insects are a butterfly and the bee. Now, when you look at the butterfly, when it gets to the flower, it does not dig deep to get the nectar. It just gets a little of the nectar and leaves that flower and gets away. But the bee is serious. It gets deep into the flower to get enough nectar for the honey. I'm trying to say something that the bee is more serious in its work than the butterfly. Is there anyone who starts a project and leaves the project half completed? So there is a project towards universal e-accessibility. The journey started with the development of the standard. Now the next question is, was that the end? That is definitely not the end. Now, and this journey can be challenging. And because of this, it's good to share experiences. How do you get beyond the publication of a standard? You know, in our context, we know the challenges. But as now, I would like to invite one of us from whom we borrowed a leaf, Malin, from the EU, to give us their experience in the implementation of the EU standard on e-accessibility of products and services. Welcome.
Thank you so much, and thank you for the opportunity to be here and talk about this very interesting topic. Apart from heading the Norwegian authority, I also headed the SAGA, the Strategic Advisory Group on Accessibility, for the CEN-CENELEC for 6 years. So I've seen the standardization from that perspective on a European level. The SAGA, for those who don't know that intimately, it was a group consisting of 30 countries and the key stakeholders from EDF and the user organizations and the big tech companies of Europe. And the aim was to give advice on accessibility, both standards, revisions, and new standards for Europe. So I think, just to mention that at the first get-go, that the creation of Africa's digital accessibility standard would be a unique opportunity to shape the future for inclusion across the continent. I think collaboration is key. I think it's very important to bring together government, industry leaders, ICT companies, and user organizations. Because as mentioned, how do you move from publishing a standard to making it something that you can implement and that both businesses and governments and others follow in their daily work? And I think a kind of multi-stakeholder model could be one way of doing this. As mentioned earlier, I think the key is to make everybody understand why we do this. A standard is, by design, often technical components, as mentioned, and it can be less engaging when just reading the standard if we don't put it into a context of why this has been developed and how following the standards affect the different stakeholders. So digital technology doesn't stop us at national borders, as mentioned, and neither does accessibility challenges. And for Europe, one of the big parts of the standardization efforts has been to make it a part of the European legislation, hence not only to aim for higher degree of accessibility, but also to underpin the internal market, which is one, I think, a key to make it business-wise to follow the same standards, making trade easier. That's why standardization efforts should be international and regionally aligned. A fragmented landscape of national rules creates confusion for developers and uneven access for users. So cross-border alignment support inclusive design from the start and ensure user benefits regardless of where they live. So with enforcement mechanism, you have the possibility to also push compliance further. Even best written standards risk remaining on paper, and capacity building is needed for institutions tasked with monitoring compliance. By monitoring and benchmarking, you can also move motivation along. One thing that we've used quite a lot of time on in Europe is shared interpretation and testing of the requirements in the standards. And I think that is just as important as the standard itself. It's not just enough to agree on what the accessibility requirements are. We should also align how to interpret and test them. Joint interpretation and shared test procedures and common reference methods are key to ensuring meaningful, consistent implementation. This can help build clarity and trust across the public and private sectors and ensure accessibility in practice, not just on paper. Harmonized standards were mentioned. I think it's very important for harmonized standards across the countries to put pressure on also the cross-border companies. A more unified message and a louder voice, Africa has a chance to lead by speaking as one. So, I would just also like to remark on a data-driven feedback loops, collecting real-world data on usage and barriers. That can help identify which areas one should prioritize. A digital data-informed authority can identify patterns over time and adjust policy and standards accordingly. So this can help us move from reactive to proactive accessibility governance. So, thank you.
Thank you, Marlene. When I was giving you the story about these two insects, the butterfly and the bee, I said that we get nothing from the butterfly, but I'm not sure how many of us realize that that was not a true statement. We may not realize, or immediately see the benefit of a butterfly, but after the fruits ripen, then we can remember the what? The butterfly which contributed to the pollination of all these things. No. But for the bee, we can directly see the what? The honey. So there is the beauty in the butterfly, in its gracefulness, which we realize later that we wish we could have many butterflies. No, and if the butterfly were to talk to the bee, the butterfly would ask, why are you always just at one place? Do this and do this and do this now. We've said that standards, or rather we've not told you, but standards in principle are voluntary. And they are standard-setting organizations. And these organizations, they develop these standards and leave the users to implement. They don't hold a rod of baton. These are the graceful organizations which do voluntary work, who work behind the scenes. No? Now, the standard, the EN 301-549, which we customize into KS 2951, there is a very important component which was developed by the W3C under accessibility guidelines. And therefore, I would like now at this point to invite the representative, the graceful organization W3C Consortium, to just tell us their experience of why they are doing beautiful work and nice work, yet we are not seeing this work. So I would like this time to welcome Daniel to give us a small overview. Welcome.
Well, thank you very much for this beautiful words. I'm going to present myself, I guess, as Maya the bee from now on, because it's the metaphor. It's very well brought up, and I think it synthesizes very much what we do. First of all, a little bit of a clarification. We do have WCAG, the Web Content Accessibility Guidelines, embedded into the EN 31549 standard. But EN 31549 covers more. The title says it all. It's about web I think it's accessibility of products and services, with which WCAG is a subset. So one of the first things W3C did realize back in the day when it comes to standardizing WCAG and making it available for regulators and policymakers is, okay, that WCAG applies to the web, and we've nailed it down as to how it should be applied. But when it comes to other digital provisions and products and services, it may not be that clear. So another extra effort needs to be done to communicate how and when certain W3C WCAG success criteria can or cannot be applied to products and services. This effort was first developed for WCAG 2.0. It was a 2013 W3C working group note. Sorry for this blur, but anyway, that's the technical name for this. And it tried to communicate back in the days 2.0, among all of these success criteria, how these could be applied to non-web contexts, basically meaning products, non-web documents and software. This served as the first source of input for the EN 31549 back in the day. What they have now is some of what we produce for 2.0, and this effort is now replicated because, as you probably know, the EN 31549 standard is going to be updated based on the requirements of the European mandate. I think it's 587, but don't take me on that. I'm just talking by memory at the moment, which basically requires CEN-CENELEC and ETSI, which are the European standards organizations, to update this based on WCAG 2.2. So the WCAG 2 ICT has developed their guidance for 2.1 and 2.2, and we're now in the process of working together with CEN-CENELEC and ETSI to include this new guidance. One important thing to take into account for the African context here is it's good to have a look at the existing discussions. It's good to go through the WCAG to ICT issue repository, as well as through the EN 31549 GitLab, because they work on GitLab issue repository. Because that's going to save a lot of kind of worms that easily are going to be opened as to how to apply WCAG to .2 more specifically, and 2.1, which are the newest ones to products and software. So first piece of advice I would give is, let's not reinvent the wheel. Let's go through what experts in both sides, both in W3C and in ETSI, have already said and have already discussed, because that's going to save a great amount of time. Second and last, just in the interest of time, would be for you to be able to, if possible, get direct input from these experts. I mean, it's always difficult. We're all very busy people, I know that, but we would appreciate, from W3C way, we would appreciate notice of the work when this is in progress, invitations to participate. We may or may not be able to, but at least we know that the work is in progress. We can help providing some advice, some extra guidance, some high-level guidance as to how to go through certain things. And this would greatly make the work easier to avoid the main danger that others have already reflected on this, but I also want to make some comments on this, which is basically fragmentation. We can interpret some WCAG success criteria differently, and that can create huge issues for companies, industries, that not only have to comply through Africa, but also in Europe and in the United States. And last comment, we've talked about the framework and the harmonized approach, but within that harmonized approach, we should never forget accessibility within the standards development process and accessibility of the standards themselves. We could have a harmonized framework. We could make all attempts possible to create standards that serve the accessibility community and the industry and the regulators. But if we don't have accessibility means throughout the process. And if we don't produce accessibility standards at the end of the day that are consumed by the general public, we're missing an important part. Thank you.
Thank you, Daniel. We are connected, and now we want to invite one of our online participants, Emma Kilada.
So thank you very much for this kind invitation. This very, very interesting event and conference. In fact, well, I have been asked to share with you a little bit the history of the standards on accessibility in the European Union, and how we came into the situation that we have today, where we have legislation requiring accessibility and standards. And the stories that I have heard of your work brings me back into my own experience on developing the standards. I have to go back to many years, to early 2000 years in which in Europe we were starting to develop accessibility policies in the area of ICT. And every time we tried to advance, it was difficult for people, for policymakers, for industry to grasp what do you mean with accessibility. So at that time I looked around and I saw two very interesting developments globally. On one hand, and you have a presentation now of W3C. At the time, WCAG was being started to be developed, and at the same time, we also had the US Access Board having a revision of their own standards. So, they have already legislation, what we did not have in Europe. So, considering the global nature of technology, what I did was partner together with the Access Board at the policy level, WCC, WCAG, WCC at the time it was Julie Brewer who was leading the group, and learned from them what they were doing and take for Europe the maximum that we could take so that we did not have to start from scratch. At that moment, I wrote what we call a standardization mandate and standardization request. It was mandate 376, in which we asked the European Standardization Organization to develop one standard on accessibility of ICT. It was a policy mandate. Basically, we did not have legislation to accompany it, so we just wanted to have a set of rules that will tell what is accessibility on ICT. And together with the stakeholders, with the industry, with public authorities, together with disability organizations, very important, and the Commission, the standard, the first version of the standard EN 301-549 was developed under the mandate of the European Commission. Now, a lot happened after that because at European level, legislation was adopted on web accessibility, requiring public sector websites to be accessible. And we wanted to use that standard that's contained in one chapter, the rules developed by, the guidelines developed by W3C in relation to WCAG, so the WCAG rules. And we wanted to use them to give presumption of conformity. This means that the standards remain voluntary in new policy setting, legally speaking. But if you use them, you are presumed to have complied with the obligations of accessibility set into the legislation. So a new mandate was issued to the standardization organizations, that was mandate 554, and that allowed to set updated rules in relation to web accessibility, aligning with the releases of WCAG, the new releases of WCAG. By the way, in the first version of the EN 31509, you can see not only the WCAG part reflected, but also that the provisions on the standard related to products and services resemble and they are coherent with what standards have been done by the US Access Board in Section 508. And in that way, we preserved this global nature of accessibility in an area in which, as I said, technology is global. Now, a lot has happened between these first versions of the standards, the second one for web, and now where we do have legislation in Europe. We have the European Accessibility Act. That is a piece of legislation that requires that certain products and services can only be placed in the market, in the European market, or can only be imported from third countries in Europe, or can only be procured by public authorities when they comply with a certain number of accessibility requirements. Once more, to accompany, to clarify, to support the implementation of that legislation and facilitate the application of the accessibility requirements, we launched a standardization mandate 587. In that standardization mandate, we ask the European standardization organizations to upgrade, among others, the standard 301549, so that the level of accessibility would be that required by the legislation, the European Accessibility Act. That means that it had to be enhanced, more provisions need to be added, and some language need to be changed in order to allow for this new higher level of accessibility that was required in the Union. In addition to that standard, as I mentioned, we have asked in this standardization mandate to develop other standards. A standard related to non-digital information, which is also very important, a standard to support the response of emergency communications, online emergency communications to the European emergency number 112, and the answer to that number, and support services like help desk, call centers, and support to be accessible. These standards are also on the making and will soon be available. And I really encourage you to have a look at it because they will help us to complement our accessibility ecosystem in support of the legislation. We also have got a standard in the line that is based on ARSO, once more. On an ISO standard, and once more there, we thought it's better not to reinvent the wheel, but just build on what is available. And one standard which is process-oriented, that is 17161, on accessibility for the design for all. This standard really helps organizations, including economic operators and public bodies, to think what do they need to do in order to ensure that the result, whether it's products, services, documents, will become accessible for persons with disabilities. I think that in this development of the process of developing this European standard, the public intervention of the government, the European Commission in this case, has been instrumental to achieve coherence in Europe. We are very happy that these standards are now available to be used by other areas of the world, but we are continuing upgrading it, improving it, and I am really very happy to see that you are doing the same. That you are taking the standard and building, localizing it to your own needs, and also improving some of its provision. I think that in this session, in this conference, is an important objective is being achieved and put in motion, which is maintaining the dialogue of different areas of on the world in order to have coherent accessibility as much as possible, and having these standards that facilitate the implementation of accessibility rules. So with that, I want to thank you for your attention, and I give back the floor to the organizer and the chair, and I remain available to continue this cooperation and to improve accessibility globally. Thank you.
Thank you, Immaculada, for that great insight. I pick one thing, that there is a regulation within EU that requires that certain products and services cannot be offered or be made available in the EU if they are not accessible. And that is both, pragmatic and important, so that inclusivity as a right can be factored in. Now, what do we do? We've started walking the path. What do we do next? We know that a bee that does not sting, we know there's some stingless bee, but we are used to bees that sting and give us honey. So what do we do in order to ensure that these standards are implemented? At this point, I would ask the one with the sting that pinches a little, the one that is in charge of laws, laws and regulations. What steps are we making to ensure that these standards are implemented? Recently, there was published the Act on Persons with Disability a couple of weeks ago. And therefore, at this point, I would ask Wilson to come and give us a talk. How do we ensure that this act, the publication of this act, supports the implementation of the e-accessibility standards? Welcome.
Microphone. So allow me to greet you once more. Don't get tired. Good afternoon. So we've just heard of a new law which came into force recently here in Kenya. And one of the provisions says that if someone who's blind addresses you and you don't respond, then you're liable for an offense. So good afternoon. Thank you very much. I just made that up. As Nicolada was speaking about certain products or devices not being acceptable in the European market based on existing standards and regulations, it reminded me of one thing, that several years ago, when I didn't have my own car, but from time to time, me and my friends could hire a car to go for social events. I would be able to pay for fuel using my bank debit card. So usually we would go to the filling station. I would insert my card on the point of sale machine, or the pin and chip machine. And because it had a keypad, I would look for number 5. You know that small button or tactile feature that is on number 5 of feature machines. You know it. So I would look for that and key in my PIN number without anyone having to see it. Now that I managed to buy my own small car and drive from the co-driver side, the opposite side, the filling stations and including other service providers have brought in machines which only have touch. And what they tell us is that we are moving with the times. And the question that always rings in my mind is, are we moving in the times with the times when we are leaving other people behind? Because now the option I have is either to give my PIN to someone else, or who could be my driver or the person who provides the service, or look for an alternative mode of payment. Now, that's a conversation I need to have with my colleague from the Kenya Bureau of Standards, now that we say we have a standard in Kenya that we should enforce. Now, I won't rehash what has already been said. I was one of the participants or individuals who were involved in development of the Kenya standard, which we have been celebrating to date here in Africa, in Kenya, and outside as well, because it's like we were leading the path for the region. And it was in a process that was very involving and participatory. But we also were told or learned in the process that it is a voluntary standard, that the obligations or the requirements that are in the standard do not necessarily create mandatory obligations. But we had another beautiful thing going on the sidelines, which was advocacy towards the development of a new Persons with Disabilities Act. By the way, this process started back in 2009, immediately after Kenya ratified the Convention on the Rights of Persons with Disabilities. And I'm told by a very reliable source that we have had 57 versions of that draft act since 2009. So now you would understand why this is a very momentous occasion for us, persons with disabilities, disability rights advocates here in Kenya, because a process that has been ongoing for 16 years has now come to pass. It has bore some fruit. So I would say, let us clap for persons with disabilities and advocates who have been involved in this process. Now, if you read the act in detail, and I'm sure most of us, especially those of us from Kenya, but also from elsewhere, we could get a chance to have a look at it. It has some specific provisions which are very interesting and very relevant to this conversation. One of the sections of the provisions, section 26 to be particular, speaks to the accessibility of ICT services and products. There are also other provisions, for instance, which speaks to accessibility of financial services, including those which are provided on the digital platform. And then there are other provisions which read in very clear terms, and as lawyers we like saying the law is very clear, but believe me, this one is very clear, that the failure to provide some of these products and services on the basis of disability alone then amount to a form of discrimination or violation of a right. Now, standards, if they do not have an enforcement or a legislation mechanism, they are voluntary. But an act which is passed by Parliament to support the Constitution, which is the main law of the land, would we consider that as voluntary? Is an act of Parliament voluntary? From the much law or the little law that we might know, is an act of Parliament voluntary? No, it is not. So already, the Persons with Disabilities Act, which was passed several weeks ago, creates a platform from which persons with disabilities, the representative organizations, and other stakeholders as well, including the bodies which develop these standards, can use or expound on to ensure that the standard is is enforced. It is a very useful platform. So maybe to speak a bit about some of the lessons that we have learned from development of the Kenya standard, which was also followed by the enactment of the Persons with Disabilities Act. And we are saying we are not yet there, but we are headed on the right direction. There are some things that we need to have in mind. So my work as a legal advisor at the International Commission of Jurists revolves around creation of standards, not those by the Kenya Bureau. We call them international laws, policies, and generally standards, which are mostly compliant with international laws. There is one celebrated instrument around the world. This one is not only for Kenya or for Africa, which we use in our advocacy or disability rights advocacy. This instrument is called the United Nations Convention on the Rights of Persons with Disabilities, which I assume most of us are familiar with. So the Convention on the Rights of Persons with Disabilities has a specific provision. It has several provisions, one of which is on accessibility, Article 9, and it requires governments or countries which have signed on to it to develop standards which can be used to assess how accessible different platforms or services are. The mantra or the slogan behind development of the CRPD, that's the Convention on the Rights of Persons with Disabilities, was nothing for us without us. Nothing for us without us. Someone told us that that is a mouthful. We have modified that slogan to be nothing without us, period. But as African students, Africans or persons with disabilities in Africa, we also realized that the CRPD, even though it also recognizes our aspirations, there are some things that are very contextualized to our region that may not be clear or specifically provided for on the CRPD. So for instance, there's a term that we often use here, is Ubuntu, right? Those of us who've not interacted with that term, please see a friend or a colleague who have, or maybe see me after this. I've given people, that's my way of making sure people come and talk to me directly. So we realized that this instrument does not necessarily capture all the aspirations or does not understand completely, 100%. It does mostly, but not a holistic perspective of the African context. So what happened? Recently in 2023, there is a regional instrument which came into force. We call it the Protocol to the African Charter on Human and People's Rights, on the Rights of Persons with Disabilities. Now that's a mouthful. The short version of that instrument is African Disability Protocol, or ADP, which holds the same force as the CRPD, only that in this case it is based for or it is enforced in Africa. And so far about 16 states have already ratified into it. Why am I saying this is relevant? We are in this convening speaking about adapting a standard, developing and adapting an African standard to inform accessibility of ICT products and services. We also acknowledge that we have had a standard which already exists in the Kenyan context. We have good practices that we could adapt from the European Union and also other frameworks, for instance, the WCAG, Web Content, the WCAG. We need to then have a standard or an instrument that also recognizes the aspirations and the lived experiences of persons with disabilities in the African context. Now, we have already had a success in domesticating the Convention on the Rights of Persons with Disabilities to the Africa region. And the Africa Disability Protocol, by the way, also has specific provisions on accessibility of infrastructure, including ICT infrastructure. We've succeeded in that front. Different countries which are represented here have either already adopted Persons with Disabilities Act, so legislation that speaks to the rights of persons with disabilities directly, or are in the process of doing that. So Uganda, for instance, has a 2020 Act. South Africa is now in the process actually of developing one, and that should actually put in consideration the conversations we are having today. We should also ensure that we work with a unified voice to have a standard which is enforceable in Africa, but that can be domesticated in our various states. Now, as I conclude, we need to think about the opportunities or some of the challenges that adapting or developing and adapting such a standard may present to us. So we've learned of some good practices. The beautiful thing about that is that we do not have to start from zero. Other people have already led the way. We know how a standard should look like, or at least the main principles that should inform it. How then do we contextualize it? How do we localize it to our region to ensure that it is also applicable to us? And even as we do this, we need to ensure meaningful engagement of all stakeholders, including the users of these platforms who we are targeting. Now, when we speak of meaningful engagement, it means that the users of accessibility devices, and I consider myself as a user. I'm using a Braille device here, which is a digital device. Whatever I'm reading, the speaking notes I'm reading from here are also on my phone and on my computer. So that's what is being displayed here. But as persons with disabilities or diverse disabilities, we have different ways in which we use these products, these services, whether they are the mainstream ones, your computers, your phones, or those which are specific to disability, to persons with disabilities. And therefore, we should also be involved in the process of developing and adapting these standards. This was a key success in the Kenyan when developing the Kenya standard. And I hope that as we proceed with the regional standard, the committee that already exists with ARSO also has users in mind or as members of the committee. But after that, we'll also need to think about domestication. So there's a complicated debate I don't want to get into, but the way different states work, and one of the previous speakers alluded to it, that even where you have a regional or international framework, some states have an obligation or require that that regional or international framework to be domesticated, whether through a regulation or another local standard or a legislation. So we also need to make sure as stakeholders that as these domestication processes are ongoing, the aspirations that are reflected or the requirements that are reflected in the regional standards are not left out. That we don't get to a position where we realize that the local standard that has been adapted, of course informed by the regional standard, has left out a critical component, or perhaps even left out a critical or one of the categories of disabilities, because diverse disabilities have different accessibility needs. As I conclude, the final conclusion, part of the reason why advocacy on the Convention on the Rights of Persons with Disabilities has been very successful, the various laws that have been adopted in various countries. So for instance, we are saying in Kenya, we adopted the Persons with Disabilities Act 2025, but it is also true for other African countries. The Ugandan law was adopted in 2020, which repealed an older law. In Zambia, they have adopted a law or enacted a law in 2019. In Nigeria, I think a Persons with Disabilities Act was enacted in 2018. I could go on and on and on. Other states like Ghana, like South Africa, are in the process of developing these acts. And I'm saying this because I'm involved in part of some of these processes. The reason why advocacy or implementation has been very, very successful is because of this component of meaningful engagement. That we do not only have the users or the people who are directly impacted by these instruments in the room. Having them in the room is not important. We need them to inform whatever content is in that instrument. And when they understand the standard, then it becomes easier for them to apply or to motivate other stakeholders to apply the standard. So we have started a good journey. The future is very bright, even though some of us cannot see it very clearly. And we hope that in the next convening that we will be having here, we'll be celebrating the existence of a regional standard which captures the context of Africa and the users, the lived experiences of the users of ICT products and services. Thank you very much.
Thank you, Wilson. Advocacy has played a central role in ensuring that we have the various acts on accessibility and disability, as well as that we have the standards. Now, this is the picture. This is the complete picture. Listen and understand. The standards describe how an accessible product should look like and how an accessible service should look like. The standards are voluntary. Now, in a society, normal society, sometimes we have rogue elements. But where we have rogue elements, there is one who wields the rod. So the rod is for the rogue elements. Now, for the good guys, they don't need the rod. Now, that is why for organizations that voluntarily implement the standard don't need the law. The law is the rod. And now that we have an act which has prescribed penalties, beware that someone will get hold of the what? Of the rod. So it is better, that's why we say it is better to implement the standard without waiting for the law to come and ask you that, have you implemented? The good thing, we now have the what? The law. Now at this moment, we should now be able to start seeing the benefits. Why are we putting effort on advocacy for the development of standards and for the passing of legislations? There is a reason, and the reason is to be able to enable and empower and then create an environment where everyone can participate socially as well as economically. And therefore, at this point, I would like to invite one of us who is going to play more or less two roles. Her experience in the development of these standards in advocacy, as well as her envision as to the benefits that are intended to be seen and to be realized through the implementation of these laws and standards. So let me take this time to welcome Ashura Michael.
My experience in developing the standards, it's not about favor or the ideology of it. As we sit in this room, coming from different countries, Africa, Europe, Asia, wherever, the question that we have is the world that we are living favorable? Developing of standards, are they going to support a specific community, or is it the whole of Africa? As my friend Wilson has said, and Nicolene, who was online, sorry to butcher the name, the legislatures and the policies which we have are there. The time, resources, the ideas which have been initiated, where are they leading us? Each and every one of us have come from various countries with one goal. Yes, networking probably is one of the goals, whereby when we get back home, what can we do back at our homes? I think developing these standards for Africa is the key thing for us. And I will leave you guys with one parting shot. I want each and every one of you, both in the private sector, in the governmental institution, all sorts of institutions, if we come up with one standard for Africa, I want you to have this in mind. To develop a standardized Africa, we should not focus on its design, but what do we tend to do? Or what should we do? Any of you has an idea of it? The design is important. As my colleague has said, about accessibility has various levels, right? And we have 3 important levels of accessibility. It's quite important, but again, it is important for us to have human dignity so that we can develop and implement these standards. We tend to have dreams to unite Africa during using those different standards. We don't have the same resources coming from various countries. I have heard of the ideas which are happening in Europe. They have some laws which are there, and some are not accessible. And that's why we tend sometimes to implement some of the things in Africa. They tend not to be implemented because maybe they are not fitting in with our context. So the importance of developing these standards, they will offer solution, yes. They will help us to have smart dreams. But how do we tend to solve the gaps which are there? I thank Enable team for having this innovative conference, which is not only about interacting or just gaining ideas, it's about partnering and seeing how we can implement these standards. We have innovators here, both in the digital space, we have the legal people. So we each have a capacity to contribute to be able to achieve these standards. I think each and every one of us, in whichever role you play, it should enable us to have an accessibility when we speak about these standards. As UNDP, our goal is to strategize on how we can work unifyingly with our partners. You said whatever happened to you, you said fund has affected billions of people, both in the accessibility part, health, education, and all that. But we all have one goal, which we might forget. The sky has 1,000 stars. When you look at all these stars, we tend to look at them as the various standards that we have. So we can contribute the various ideologies which we have. I know resources are important, but as well as human, we can offer the resource as ourselves. Human resource means what? Innovation. The goals which you have. Yeah. Google has different partners who have come here. Microsoft are here. Meta is here. What can we do? When we step out of this room, let us kindly dream about the visions which we want to make it possible for us to achieve our dreams. How and when and who to do so is the question. How, when, and who? How are we going to make this happen? Who will make it happen? Who is going to contribute into it? And when is it going to happen? The next conference probably is in 12 months. So we have a 12-month period. Will we be able to make this happen? Do we have the resources? Let's use and let's challenge ourselves within the 12 months frame that we have. And please just remember one thing. To develop standards that are impactful. It's not only about the design, but let's remember the human dignity of persons with disability and the services which can be offered to them, and the 16 million people in the world living with disability.
Thank you, Shura. Her name is very close to my name, you know, Michael and Mika, you know. And she's just told us that we should live here and start dreaming as to what we would like to achieve. But I think we must challenge ourselves, as we've seen, that what is it that I personally and you is going to do? And because of this, we are going to share with you on the screen a barcode. Please, we give you time to scan it, to commit that you will do something. You know. You must start with yourself, then you move to your neighbors, and to your home, and to your family, and to your workplace. You know. What is it that you are going to do as an individual, you know, right, you know, after this? So you will see the screen there. Please scan it. I think there will also be a URL which you can type in if you are not able to scan the barcode. Now, we've gone a full cycle, and the speeches and statements have been summarized, or rather climaxed by Ashura. Now, we take this time to invite comments and questions.
Good evening. My name is Karen Morioki. I represent two organizations, one of them being an edtech company that is based in Tanzania, Ubongo Kids. I know most of you know about cartoons for children, and the other is an OPD that advocates for autistic people. Mine is just to touch base on creating accessibility standards in edtech. This has been my baby. I've been advocating for it since last year. I realized that there is a very huge gap in edtech products in trying to make it more accessible to learners with disabilities. So my question is to the audience, even as we end this discussion, what is your advice, especially to some of us who are very keen on advocating for inclusive edtech so that it meets the standards of Africa accessibility? Thank you.
All right. What is the advice which can be given? The next hand was here.
Sorry, good evening, everyone. My name is Engineer Issa Siaka from Nigeria Standard Body. Thank you, the ISO representative. I think from what you said and all comments, we are going away from it. Standard needs money. And what we expect to do from here, from this particular meeting, this enable, if we can join hands with you. I know several times organized Zoom meetings and everybody, I've seen the number of people joining. I took time when I got this invitation to go through the technical session, the technical clause of this standard. There is no country that goes through it that will not adopt it. Then, possibly, I was even looking at maybe the web content of it. The web, the W3C is here. So those have been the back for what we are looking for. Every company, every country that goes through this standard will definitely adopt it. And once they adopt it, we are not adopting the software part of it, the back end. Is what is coming in. That is the phones, is the equipment, the terminal equipment that those people are using that we are going to enforce. By the time we are enforcing it, you'll be sure that even shops, supermarkets, and other things that avoid it, they will use it. The law will come in place. Africa has a big potential for marketing. And we have a lot of people that can invest in this. But if we sit silently and wait for country to come, they won't come. So if you can go in, maybe joining hand with the Enable Inclusive to organize that webinar that you used to organize. Because by the time they do this topic and you ask for experts from every country, they will be available. Thank you, sir.
Good afternoon, everyone. Thank you so much, our dear panelists. My question will go to my learned colleague Wilson, and really it's just to seek more knowledge to understand from his sharing. So I'm trying to understand from the Kenyan context, why were the standards developed before the Act of Parliament? And what's the implication of that in terms of their enforceability, but also just to learn if at all the Act of Parliament recognized and ratified them, or what their position now is. But I would also want to still understand more in terms of where the difference lies between the standards and the statutory instruments that would come out of an Act of Parliament to set regulations and procedures on its implementation. Otherwise, thank you so much for updating us on the different Acts of Parliament across the regions. I still remain challenged, and I know there's a lot of advocacy for us to do, especially in the context of Uganda, because what I've heard from the Kenyan Act of Parliament is that it's very progressive and it puts in place very many provisions to support the community and caregivers. Thank you.
Thank you, and thank you for the good presentations and input from the global point of view, disability and accessibility. My name is Nicodemus Nyakundi. I'm from KICTANET, that's Kenya ICT Action Network. I'm very much interested in the Kenya standards. And this is because we did an extensive study on the standard when we were gauging the accessibility of government websites to persons with disabilities. And we found that the standard is well put, but usually what is missing is implementation. And in this, usually it comes because there is no proper oversight or watchdog. Because those who are supposed to be implementing the standard usually saw no need of implementing it, and thus they go scot-free. So my question is, maybe from the global perspectives, what should be taken by the relevant authorities against these platform owners or people who should be responsible for promoting accessibility? Thank you.
Am I audible? Okay, there it is. My name is Senzo Bonambi. I'm from South Africa, from an organization called Lead Change Developments. I just have two questions with regards to the standards, especially looking at the African standards. As organizations, we are the custodians of our beneficiaries, and we have a better reach to reach beneficiaries deep in rural areas. From a standard point of view, looking at the committee, I think one of the speakers had clearly mentioned the issue of budget. How can we, from a committee point of view rather, champion all the organizations that are present here to ensure that they discern the information, unpack the information from the standards, and then render them out to those beneficiaries at grassroots level so that we know very well as to the information has reached the deepest and deepest of the beneficiaries by championing them and allocating maybe a certain budget towards the organizations moving forward. And then the second one is, in my country, with regards to the Disability Act, especially when it comes to employment and business, there's a lot of acts that suggest that from employment you have your 7% quotas, and then from business then it's 30% and so on and so forth. But by virtue of that, companies are not necessarily following such, to a point that at times it gets to a point where they will even rather pay a penalty than to employ a person with a disability. But now what I'm simply asking is, what other right-wing sort of kind of resolutions can we come up with? Because when I'm here, what I've seen in this conference is there's a whole lot of innovators that are here. How can we then empower them using these standards looking forward, and then to offer such options to those that don't necessarily want to look at reasonable accommodation, but they can then purchase this, and then we can look at it from an empowerment point of view, but we then use these standards moving forward. I pause, and thank you.
All right, I think we are now going to respond to these questions. Technically, there are 1, 2, 3, 4, 5. And I would like to combine them as follows. Engineer Ruben is going to address the EdTech question on advice needed on how to ensure that some products meet accessibility. And then he's also going to address one of the questions from South Africa on promoting standards deep into the rural area, given that now we are looking at this thing at a continental level. So I assign Engineer Gisore those two. Then after him, Wilson will address the Act issue. Why do we need the Act to go through Parliament, and what benefit do we get from having the Act? That is implementation. And then Wilson is also going to address the other question that, for example, in South Africa, companies would rather pay penalties than meet the legal requirements of ensuring that at least a percentage of employees or number is for the persons with disability. And then I'll respond to the standards issue which has been raised by Nyakundi of ICTANET on implementation gap. Thank you. So let me invite Engineer Jiang.
Thank you very much. And perhaps the one that is not meant for me is one of the most interesting, that the standard came before the law. It happens all the time. Either one of them can come before the other. But actually, it is better when the standard comes before the law, because then the law can refer to that standard and make it easier for compliance. Because in that case, the law does not need to be laid by itself on how you are going to comply, because it will make reference to that standard, that it will be easier for you to comply with the law if you actually follow that standard. So it can also be the case that the law can say that it can come first, but it doesn't then refer to a standard, but those who are framing the standard will make reference to the law. So either way, you find that both of them combine and support one another very well. But from the standards point of view, we prefer that the standard actually always comes first. Then it makes work so easy for the lawmakers that they can make reference to that standard. That gives the standard a lot of power so that it becomes very powerful in the country. Now that brings us to the other aspect now. When you have products that you are advocating, and you want that they should comply. That is where the law now comes in, that you make reference to that, bring it to the attention of those who are advocating and those who are producing the products, so that they understand that when they are not making the products accessible, they are actually violating the law. And that's why when Wilson was saying, is the law voluntary? It is not voluntary. There is no law that is made and is voluntary. Then there was no need of having a law. And therefore, if they start law in the country and there are products that need to comply, your advocacy should be best and strengthened by making reference to that. But I know that sometimes the advocacy suffers from lack of either financial support or legal support. And this is where you need to work with the lawmakers or those who are implementing the laws. You'll find that in many countries we have the institutions charged with that. But perhaps it is then their ability to come out and say, let's work with those who are advocating for the advocacy groups. Let's work with them so that we can enhance the compliance. And once that is done, then you are easily able to comply with, you can achieve that. Well, it takes a lot sometimes. In some countries, it is always the case that advocacy groups don't work very well with government. So it is the duty of government to understand those advocacy groups and the complementary role that they actually play to ensure that the laws are complied with and to work together, because we are working for the benefit of the community, of the society. The government is working for the same reason. And so there's no need for you to have a difference or not have a good understanding of one another. The last point was what?
So the last one was, I think you've almost talked about them, advice on products,
Okay,
and then
rural areas. Taking these standards to the rural areas.
Yes, the rural areas.
South African participant. I think we will need to look at the design of the project when we actually start looking at it. In ARSO, what we have been doing is to develop what we call outreach materials and to even have awareness missions which we organize with people in their countries. So when we are deciding this, and I think perhaps George should have known this, when we gave them the budget, it was quite high. It is because we don't, for once, assume that when we do the standards at the head, the capital cities, that we have done justice to the societies. We need to move the knowledge down all the way to the rural areas. And for that matter, we develop materials that explain how the standard should be implemented in a very simplified language, not that very technical one which the lady from the European Union was talking about, so that it makes it easier for people to understand why are we asking for certain types of compliances to be met. It is for that reason that we develop the outreach materials, and to do that and work with those who are representing communities to actually reach out to the people at the grassroots level So I think it's the design that we need to look at and ensure that we can meet those requirements. So let's not be comfortable that we will have launched the standards at the capital cities and assume that we have reached, all the beneficiaries. Thank you.
Yes, thank you.
Thank you for those great questions. One of the things that I have learned while in my work as a self-advocate, but also as a lawyer, is that you'll hardly ever find one solution that fits all, or one instrument that creates all the good practices in terms of standards. You have to get bits and pieces from different places, and the main call usually, or the hope, is that what these instruments provide for is consistent. So jumping into the question, so I'll address some which, a bit of what engineer has also spoken about. There was a question by Karen about EdTech. So one thing that you will realize when you, for instance, just read the heading of the Kenya standard, and I'm sure will be the position of the regional standards when it is developed, is that they apply to all ICT products and services. So the main question that I would have is, the EdTech platforms, would they fit as either a product, a service, or even a device? And if it does, then it means that those service providers or those platforms also ought to be compliant. We said the standard is voluntary, but now we also have an act which expressly creates obligations to ensure accessibility. And in the absence of which, we still have other provisions of the law, for instance, the Constitution, the Convention on the Rights of Persons with Disabilities, which we can apply. So it's important to do that. And the approach that I always propose is that when there's a service provider or a platform that we understand not, or in our experience is not accessible, even as disability rights advocates, we need to propose solutions to them. We need to tell them or even refer them to the existing standards or requirements, for instance. And if they fail to comply, then what do? Mika said, use the rod. See the law, use the law to support your claim. Take them to court if you need to, although there are also other mechanisms that are existing. So for instance, I believe the Kenya Bureau of Standards, they have a tribunal or a mechanism that one can present claims before. And then the question about, engineer has already spoken about the difference between the standard and the law, but it's also important for us to understand that, as I said, there's no one instrument that can answer all the existing questions. It's good to have a standard, it's good to have a law, but it's also important for us to enforce them, and where they are not enforced, claim for their enforcement. So even when you have them, for instance, we could have a very beautiful act here in Kenya and other countries that I mentioned, but if we do not claim for the rights that are provided for there, if we do not provide the requirements which are on these standards that have already been adopted or those that we'll establish, then they will be doing a lot of shelf help. They'll be gathering dust on the shelves. And then the last, a question about South Africa and the quota system, actually, which is applied, I think, in majority, if not all, the countries in Africa, especially those which have laws or policies that speak to disability. So, for instance, even here in Kenya, we have a provision under the Constitution, even before the Act, that says 5% of employment and appointive positions will go to, should be provided to persons with disabilities. And then they add that a qualifier, which is progressive realization. So we ensure that this will be progressively realized. The problem or the biggest issue with that has been that an entity, in fact, let's use the government as an example. The government can claim that it has 0.5% of its workforce as persons with disabilities in 2025, and then claim that it has 0.6 in 2030, and say we are progressively realizing this provision. An approach that I have seen work, I wouldn't say it's good practice, but it's something that could be considered. It could work different in different jurisdictions, but I'll use the Kenyan example. Some of the provisions of the new act, they speak to the same quota, so 5% of employment positions in private and public entities or government entities to persons with disabilities. But then it includes a clause that does not only have penalties, but also incentives. So for instance, there's a provision that states that when an entity employs a person with disability, the resources or finances that it uses to accommodate them, to provide reasonable accommodation to them, or to modify the office, the infrastructure, and other systems to make sure that this person with disability is accommodated, then they can claim for tax refunds or reduction of the tax that they pay. Now that is an incentive to a potential employer. We need to also consider incentivizing as opposed to just penalizing. Both of them should be considered, but we should take advantage of them. As I conclude, because I'm a lawyer and I have to speak about litigation, we have several countries which are represented here that do not necessarily have a standard on accessibility of ICT products and services, or maybe even a Persons with Disabilities Act that is recent, that is compliant with the CRPD, and so on and so forth. Some of us might have heard of the Marrakesh Treaty, which is an international instrument which speaks to the accessibility of reading materials, published works for persons with print and visual disabilities, right? Several countries have ratified the treaty, but an example of a country that has not ratified the Marrakesh Treaty is South Africa. This treaty establishes an obligation for governments to review their copyright laws. So South Africa, having not ratified the Marrakesh Treaty, then it has not accepted the obligation to review its copyright laws to make sure that reading materials could be modified or provided in accessible formats. But an organization called Blind South Africa went to court with other parties. The organization I work for, ICJ, was a friend of the court in that case, and they claimed that even though South Africa has not ratified the Marrakesh Treaty, South Africa has ratified the Convention on the Rights of Persons with Disabilities, which also requires accessibility of different products and services. And the court actually directed that the government revises its copyright laws. So that's a good practice that we can adapt, but sometimes not necessarily wait for us to have a local framework, which we can then use to put duty bearers to task. Thank you.
Thank you. I think what I could have addressed has actually been addressed. It's around the implementation of the standards. And there are several provisions, including legal requirements, making implementing the standards a legal requirement. But we recognize that it is the duty of every one of us. Now, before our built environments had ramps, we were okay with them, but there was a problem. But as soon as they had ramps, everyone were using them. Everyone was using the ramp instead of the what? Of the stairs. No, because it is easier to walk along the ramp. And that is the same case. It is easier to use an accessible product and service than one which is not. So the first step is us demanding for what? Accessible products and service. That is the first step, because we recognize their benefits. Now, we are coming to an end of this session, and so far there is no other hand. So question time closed. Yeah, there's no protest, so it is confirmed closed. Now, at this point now, I would like to ask you that you may be approached by some of us in an orange label to request for a feedback. So please don't resist. When you're approached, please provide what? Feedback on this conference. I think at this moment, I would take time to, if there is any of our participants who are still here with anything to say. All right. Yes, I think I would ask Daniel to say something as a closing remark. Then I would hand over to George to wind up this session. Thank you.
Yeah, thank you. Thank you very much. Just closing, it's very exciting to see the commitment from different stakeholders around the table to look forward and potentially have an Africa standard. It makes me feel very good that we can have this opportunity and once again offer the collaboration from W3C way more specifically. If you want to reach out to us, you could just follow the link to the WAI website at w3.org/WAI. And again, it's one of the things that have been said several times, but I don't resist to again repeat that as important as having the standards themselves and having the harmonized framework is to have accessibility all throughout the process. Otherwise, we are going to fail when including people with disabilities in the standards development process. So reach out to your disability organizations that are closer to you, reach out to individuals. We've had extraordinary remarks from people with disabilities in the room who are also high-level experts, and that's a very huge opportunity. So thank you all once again, and looking forward to coordinating with you in the Africa standard.